Namaste and welcome to the presentation on Payment of Gratuity Act 1972. It is quite appropriate at this point in time that we have a look at our first presentation on industrial laws, wherein we said we will be learning about 7 acts starting from Factories Act and going up to Payment of Gratuity Act. Payment of Gratuity Act 1972 is the 7th in the series. This completes the picture of industrial laws put through the template of the 5-step process. Let us get into the last but the most important of the industrial laws, Payment of Gratuity Act 1972. As always, we will be studying it under 5 components. What is Gratuity Act? What is the concept of gratuity? What does the Act of 1972 mean? How does it apply? And when you apply the Act, it affects 2 people, employer and employee. We will see in detail as to who is an employer and who is an employee. Then the second stage, we will get into what are the 5 key components of Payment of Gratuity Act. It talks of a minimum service. It talks of a continuous service. It is called as the terminal benefit. It has got a ceiling on the maximum amount that can be paid, and there is a formula. We will study these 5 under key components. Then, as a part of standardization, it has got processes. When you join a job and you complete specific amount of service, you have a nomination process for gratuity. You can nominate a family member. What happens in the event of death of an employee? And there is a provision for forfeiture of gratuity as a special situation. After that, we have to just see how does the gratuity process work. When your gratuity is ready to be paid to you, do you need to apply for it or it comes on its own? Who decides its value? Who will make the payment and report to the concerned authorities? If there is a delay, what happens? Is there a dispute redressal mechanism? And how is the final settlement effected? An authority which oversees the redressal of grievances under the Act, that authority is called controlling authority. How is he appointed? If there is a redressal to be done, within how many days the complaint has to be lodged? What are the powers of a controlling authority? And how does he go about recovering dues? And can gratuity be attached? These are the specific situations we will be looking into in the subsequent slides. Let us get going. Let's come to the first part of it, Payment of Gratuity Act 1972. What is the concept? Gratuity as a concept is more as a token of gratitude. An employee serves a company for a long period of time and he is leaving, and there is a parting gift with the thanks. And as a term, gratuity talks of contributing to the retirement life of an individual for his contribution to the company. It is a parting gift, and the gift was voluntary because it has more to do with gratitude and feelings of the employer towards the employee, wishing him all the best. This voluntary gift has been converted into a mandatory obligation through a central legislation, and which is this particular act, Payment of Gratuity Act 1972. This is Social Security Welfare Plan. Its main intention is to get a kitty of funds to an employee who has spent a considerable part of his life on a particular job. Now, gratuity is no more a gratis. It is a mandatory obligation of the employer to reward an employee when he is leaving the services of the company subject to conditions. And that way, Payment of Gratuity Act 1972 is a milestone in the social security legislation of the country. To whom does this Gratuity Act apply? It is applicable to employees and employers. And who is an employer and employee? We will see in the next two steps. And it covers what? It covers factories, mines, ports, and when you say factories, factory as defined in the Factories Act, and shops and establishments which are not covered under factory. It is a parallel to factory. Factories, shops and establishments. In case of factories, there will be a manufacturing process. In case of shops and establishments, there won't be a manufacturing process, but there will be operations. And they will be covered under Shops and Establishment Act of the respective state. What is the requirement? Third requirement is that establishment or shop or factory should have 10 or more employees. The moment, and during what period? During the preceding 12 months. Preceding 12 months. And the moment you reach 10 or more, you are attracted by the act, the Payment of Gratuity Act start running with that company. And as we have seen in other acts also, once you enter, you remain active under the act. Tomorrow, if the number of employees is going down below 10, can you go out? No, it is a one way. You enter Gratuity Act, you stay there, irrespective of the number of people that you have got. We have got the employer. Who is an employer? Basically, we are talking of two sets of people. First set is a person or authority appointed by the government or the owner for the supervision and control of employees. This is particularly in respect of a government company or a company or establishment owned by a local authority. In case of other companies, say from the private sector, the person or authority who has got the ultimate control on the entire affairs of the company. He may be a manager, managing director, or other names. Why employer is important here? For the simple reason that he is answerable for all obligations under the Act. Who is an employee? Employee is one who is employed with the terms of employment, may be oral or it is under a contract, and the work may be manual or otherwise, and this work has to be connected with the establishment, shop or establishment or factory. Now this employee, when we define, it includes everyone, but it doesn't include an apprentice under the Apprentice Act. Therefore, Gratuities Act covers everyone who works with or without a contract, oral or written contract. And it may be manual or a physical labor, but it has to be working in a factory or a shop or establishment. We have Payment of Gratuity Act. Its 5 components as to what is the concept of gratuity, how does it become a mandatory one, then to whom does it apply, and who is the employer and who is the employee. Key components of this scheme of gratuity under the Act. The first concept that comes into is the minimum of 5 years. An employee to be eligible for gratuity has to put in a minimum of 5 years as his service. It has to be continuous. It is the gap between the date of joining and the date of leaving. This 5 years is insisted in every case. However, exception is in case of death or disablement. In case of death or disablement, the service will be considered from date of joining till date of death or disablement, and the formula of gratuity is applied for that duration. But there is a small relaxation of 5 years of service as noted by the Supreme Court in the case of Mettur Birdsell versus Regional Labour Commissioner. In that particular case, the employee had put in service of close to 5 years, but less than 5 years, and the employer refused to pay the gratuity. Supreme Court said, Payment of Gratuity Act is a social security legislation. There cannot be strict interpretation of the act. There should be liberal interpretation and more in favor of the employee. The court said the service need not have to be full 5 years. It can be 4 years plus 240 days in the 5th year. It can be considered as continuous service. And it also went forward and then said, if the company is following 5 days a week, then it has to be 4 years plus 190 days in the 5th year. In both these cases, it said the requirement of full 5 year service is considered to be complied with. It forms continuous service. The concept of what is continuous service comes into picture. Continuous service means uninterrupted. There is no break because of the action of employee. But if the break is imposed by factors beyond the control of employee, then break is not a break. It is uninterrupted. Which are the cases where the break doesn't act as an interruption? If it's a paid leave, if it's a temporary disablement in the course of work, if you go on sick leave, or if you avail maternity leave, there is a strike, there is a lockout, or there is a layoff, all these do not break your service. Your gratuity remains unaffected. And the continuity in service is considered to be intact. And gratuity has got a special feeling and meaning. It is paid at the end of service, date of leaving. It is terminal in nature. They call it gratuity as terminal benefit because of that reason. It terminates the relationship. It is paid at the end of relationship of employer-employee in one organization. It has got 3 connotations to be noted here. It is paid either on superannuation, or on retirement or resignation, or on death or disablement. What is superannuation? Superannuation is the date fixed in the contract for closure of employer-employee relationship. Whether you close or not is not material, but it is recorded in your contract that your date of superannuation is on attaining this particular age on this day. That will be the basis for calculation of terminal benefits. Second, on actual retirement, you resign on a particular day and you are going to be relieved on a day. You have to note one point here. Date of retirement is the date of last day of service. It is not the date of resignation. Resignation is an indication that the termination is going to happen. But gratuity will be calculated till the last day. That is the day of retirement. Third, it can also be paid on death or disablement due to accident. Death in the normal course of time. Disablement is caused in the course of work by way of accident or disease, work-related diseases. Thus, it is a terminal benefit occurring at the end of employer-employee relation. Is there any ceiling on this gratuity which the companies pay or the employer pays? Yes, there is a ceiling.
Ceiling from what angle? Ceiling from tax angle. Government has fixed a ceiling of rupees 20 lakhs on gratuity received by an individual or an employee in his lifetime. For the entire life, you can have a gratuity of 20 lakhs and still not pay tax. It is exempt from tax. But your gratuity has to pass through the test of the formula. What is the formula? We will come to know in the next. If, as per formula, if you are receiving 25 lakhs, in that case, 20 lakhs is exempt, balance 5 you will pay tax on. If a formula says you are eligible for 10 lakhs, your gratuity will be restricted to 10 lakhs, which falls within the exemption limit of 20 lakhs. You don't pay any tax on that 10 lakhs. Means any payment that you receive over and above formula calculation, it is taxable. Can an employee pay more than the tax-free gratuity? It is up to him. It is voluntary payment from an employer. If the employer pays more than what is permitted by the Act, so kind of him. But only thing, employee has to pay tax on that amount. And that brings us to the formula part of it. What is the formula? Gratuity is calculated by a formula which has got 3 parts. It considers last drawn monthly salary. Last drawn monthly salary means, for example, if you have applied for termination by the end of January, 31st December, previous 31st December will be your last drawn salary. What the last drawn salary includes? It includes basic plus dearness allowance. Okay. What is the second component of the formula? It says 15 divided by 26. It suggests for every completed year of service, you will get gratuity equivalent to 15 days. And what is this 26? It is 15 days out of 30 working days, which relates to 26 actual days. Since we are taking monthly salary, the 15 days is converted into a month by dividing it by 26. They are comparable. Into number of years service. What is number of years service? If your service is say 4 years 3 months, it will be rounded off as 4 only. If your service is 4 years 7 months, it will be rounded off as 5 years. Thus, this formula is quite crucial and important for the calculation of gratuity. Last drawn salary into 15 days divided by 26 working days in a month into number of years of service duly rounded off. 6 months and above rounded off, and less than 6 months is considered as ignored. Minimum 5 years as the service required to be eligible for gratuity. And here we have to just note one thing. Gratuity doesn't come into being proportionately from day one. It arises at the end of 5 years. All of a sudden it emerges and then sits there in the books. Although companies make provisions on an annual basis. This is to say, if your service is only 3 years, you have not earned any gratuity. It is zero. It has not come into being. It comes into being the moment you complete the minimum service of 5 years or death or disablement. And we have seen the continuous service, terminal benefits.
What is the process? Process is simple. The first process talks of nomination. When you join a company which is attracted by Payment of Gratuity Act, once you complete 1 year of service, you have to make a nomination filed with the company for its records. And when you make a nomination, you are nominating a person to receive the gratuity in the event of your demise. And the person who is nominated has to be one or more members of family. You have to remember, it is a family member who can be a nominee. If you don't have a family, no relations or no members as defined in the family, which we will define separately, then nomination can be made in favor of any person, any outsider. Okay, subsequently you get married and then you set up a family, then the old nomination becomes invalid, and within 90 days of acquiring a family, you have to make a fresh nomination. And every nomination or change shall be in writing and it shall be witnessed by two people. The whole idea is to ensure that gratuity, which is a lump sum paid at the end of service, should be received by the family members, and hence nomination has to be on one or more of the family members. Okay, now what is a family? Simple. A person who is employing may be husband or wife, or male or female. If he is husband, himself, his wife, children, parents if they are dependent of himself, and if he has got a predeceased son, a son who has died before him, that son's wife and children. This is family. His nomination has to be like this. Same thing happens to the wife. Wife, her husband, their children, her parents, and if there is a predeceased son, widow and children of that predeceased son. This is family for the sake of gratuity. Now what happens? On the death of an employee, the gratuity will be paid to the nominee because it is already documented. If nominee is not there, then to the heirs of legal heirs, they have to get a court order or probate of will or something document like that in support of their right as inheritors. If both nominee and heirs are minors, the amount will be deposited with there is an authority under the Act called controlling authority, which we will study separately, who will be collecting the deposit of gratuity, and he will maintain that amount, and the legal heir will get once they come out of minority. Whenever a person dies, the nominee or legal heir can approach the company if the company doesn't pay on its own, and they have got time limit up to 1 year to apply for gratuity. This is a simple process, and as we saw, gratuity is a lump sum paid in gratitude at the end of service. Now, can the company forfeit? Forfeiting means withdrawing, holding back, refusing to pay. Naturally, as a social welfare legislation, as a collection of money at the end of service, the amount is not forfeitable. But the Act of 1972 lists 3 cases where it can be forfeited, and it also states there should be a process of forfeiture. You just can't say the law says it can be forfeited and therefore you forfeit. No. What are the 3 cases? 1, if the employee with his willful omission or negligence has caused loss or destruction of property, forfeiture is permitted to the extent of loss. Company cannot make a profit out of this forfeiture. It can recover the amount of loss caused to it by the willful omission or negligence, and balance it has to pay to the employee. Second and third, in these 2 cases, forfeiture can be wholly or partially. It is at the discretion of the company. One is riotous or disorderly conduct, violent behavior, and second one is act of moral turpitude in the course of employment, say sexual harassment or something like that. Now, in both cases, the company has to follow a process. It has to issue a show cause notice, hold a hearing with witness and evidence, hear the employee, and then decide, and there should be a following order of termination of the employee. Without show cause, hearing and termination, you can't forfeit gratuity. And if you come to the third situation, in addition to show cause, hearing and termination, in cases involving moral turpitude, it should also be supported by a court conviction under law, because it is a matter of offense under the criminal law. In that case, besides your internal hearing, there should be a court conviction under the law. Now, these are the three situations where we can forfeit the gratuity of an employee. As we saw, under a process of gratuity, there should be nomination. There should be nomination in favor of a family. What are the steps to be followed when there is a death of an employee? If there is no death, it will be received by the employee himself on the last day or period subsequent to that. And we also have an option of forfeiture of gratuity. From there, we come to gratuity process. Now, what do you mean by this? What happens when the gratuity is actually due to an employee? How does it work? Where does it start? Where does it end? Of course, it starts with the application and ends with the settlement. Let us go stage by stage. Application. See, when I am retiring at the end of say April, I can write to the company 30 days before 30th of April. They say 31st of March. The employee can tell the company that I am returning on this particular date and I want to apply for my gratuity, which will be due when I leave the company. Oh, fantastic. This is the application part of it. Once you apply to the employer. Who decides the value of the gratuity? Employer has got a family. He has got a formula. He has got the nomination. He has got the pay records. He applies the formula and determines the gratuity. And immediately he will give a notice to the employee specifying what is the amount of gratuity he is likely to get. And he will give that notice both to the employee and he will also send a copy to the controlling authority who is head of the act for the country or for the appropriate region. Now the value of gratuity is decided after the application. Then what is the obligation of the employer? Not just calculating and saying you are eligible for it. He has to pay within 30 days from the date it becomes payable. As we saw, if a person is retiring end of April, the company is informed ahead of it 1 month, and 30 days from the end of April, it becomes payable. Within those 30 days, it has to be paid. It can be paid by check, DD, net banking, and the payer, after paying, will also inform controlling authority. Just like a CC, complimentary copy will be sent to him. Now here he is supposed to pay within 30 days after the amount is due. If he fails to pay that, the controlling authority can pass an order asking him to pay interest of 10% per annum for the delayed period, because it is a due which is which is paid not on the due date. Then if there is any dispute in respect of gratuity, in respect of the claim, or to whom it has to be paid, who is the nominee to be paid, any issues pertaining to the payment of gratuity and in the whole process, any confusion is there, the buck stops at controlling authority. One has to approach them and get the dispute redressed. And once he receives the complaint, and whenever there is a dispute, employer will play safe. What he will do is he will deposit the amount with the controlling authority, and the controlling authority will keep it with him. And once he hears, reviews, and when the dispute is settled, he will make the payment of gratuity at the right amount to the person. That brings the process of gratuity payment to a close. It starts with application. Employer determines the value, sends a report to controlling authority, and it has to be paid within 1 month after the due date. And if it is not paid within 1 month, there is an interest to be paid. And if there is a dispute, one has to go to the controlling authority, and the final settlement will be made by the controlling authority. That leaves us with the last aspect of the Act. There we have got a position called administration of the Act. The administrator is called controlling authority. He is appointed by the appropriate government. If it is for a state enterprise, it is by the state government. If it is for a central government establishment, it will be by the central government. There may be, for each area, there may be one controlling authority, or one controlling authority may take care of more than one controlling areas. The employer or employee, whoever has got an issue on the nomination or amount of gratuity, or if there is a fight between the employer and employee on the terms of payment, any one of them can apply to the controlling authority within 90 days of the arisal of the dispute. And controlling authority will follow the process of redressal, and he will sort out the matter as per process of law. Means controlling authority acts as a court. He has got all the powers of a civil court as given to him under the Code of Civil Procedure. He can summon the people, make them attend the court, present documents, affidavits, and he can issue commissions to them to get details, and he can decide as a presiding officer. After hearing, he can pass orders. And is his order final? His order could be appealed, and the appeal has to be submitted to the appropriate government or any other authority. It will not go to another court. It will go to another authority which will look into the grievance. And we have to see the powers of controlling authority are such that he can ensure that every employer meets his responsibility. If there is an arrear due from an employer, the controlling authority can issue a certificate to the collector to recover it as an arrear of land revenue by seizing his assets and auctioning them or selling them. And the proceeds could be used to pay the person who is supposed to receive the dues. So much for recovering of dues power of a controlling authority. And as we have seen, just like any other statutory benefit, no court order or decree can attach gratuity payable to an employee. That talks about the appointment. Please let me know your comments. Thank you so much, and thanks a lot.